Now, you didn't immediately alert Leslie Ann as to, as far as you were concerned, the fact that this accident had taken place, correct? Yes. Why not?
I didn't 100% know that it was going to break the machine. I just thought maybe it would need to cool down.
Well, did you turn it on?
Pardon?
Did you turn it back on and see that the lights were working?
No, I just left it to cool down, and then she was back the next day. I didn't plug it back in.
This machine comes with a 5-year warranty. Very important. You telephone the company, and what did they say?
They asked what was wrong with the machine. I told them about the mishap, and unfortunately it is consumer misuse.
Were they prepared to do anything?
They believed it was irreparable because it had destroyed the electronic plates.
That's probably right.
The problem is that the water wasn't just running for a minute or two, it was running for so long.
What you're seeking today is two things. First of all, obviously financial remuneration. I'll come on to that in a second. But also clarification, because it seems to me that although you're cross about it, your main issue here is to determine the extent to which an accident is recoverable in law. You accept that she didn't break this thing on purpose, correct?
No, it wasn't malicious at all.
Absolutely not. But she nudges the water, goes out for work that day, comes back perfectly innocently, and the thing is broken. You're claiming for two sums, £3,500 for the initial model, correct?
Yes.
Well, I have a problem with that because you went and replaced it with another one.
I did, Judge.
How much was that?
I replaced it with a lesser model of £1,500 because I couldn't find the full funds for the flagship model.
Leslie Ann, you lent Sharon this machine. She looked after it as best she could. She looked after it in good faith. It seems to me in the circumstances, what she did by accidentally putting a mixer tap onto hot was one of those things. She wasn't necessarily negligent. However, the fact that she left the house at speed without being confident that the water was shut off was the ultimate reason that that machine broke. Now, on balance, therefore, it is your fault. Had you not been, as you described, busying yourself with other things, this wouldn't have happened. Now, it seems to me, madam, that nudging a mixer tap in that way by accident and putting it on hot is a perfectly foreseeable risk. To that extent, I'm not prepared to replace a new one. I am, however, prepared to put you in a position you would have been but for Sharon's mistake, which is the value of a new machine which allows you to continue with your business. The order of this court, therefore, because of the unfortunate accident, is £1,500. That's the order of this court.
Leslie Ann was awarded £1,500 of her original claim to cover the cost of her replacement machine. Let's find out how both parties felt about their day in court.
I would have liked to have got the full amount for the machine. I was brought up, if you borrow something and you break it, you have to replace it. But I do understand the judge's ruling that it was a mistake. He feels that, you know, compensating me with a machine will allow me to carry on my business, and it will.
It was really my fault. I was in care of the machine, so I was therefore responsible for it, so that's absolutely fine with me.
I know you didn't do it on purpose, and our friendship is more important to me.
I know, me too. Love you.
For more Judge Rinder cases, click here. And if you've got a legal issue yourself, get in touch with us by clicking over here.